The United States Supreme Court has officially moved forward with a case that could permanently dismantle every so-called assault weapon ban in the country. After more than a decade of avoiding the issue, the court is no longer standing on the sidelines. This is not a procedural delay. This is not a quiet remand back to the lower courts. This is a direct confrontation with one of the most controversial and divisive gun control policies in modern American history. For millions of Americans, this moment has been a long time coming. For states that have built entire regulatory regimes around banning semi-automatic rifles, the ground is beginning to shake. And for the lower courts that have upheld these bans for years using legal tests that appear nowhere in the Constitution, the clock may finally be running out. The Supreme Court's decision to move forward signals something unmistakable. The era of judicial avoidance on assault weapon bans may be over. For years, gun rights advocates have filed case after case challenging assault weapon bans in states like California, New York, Maryland, New Jersey, Illinois, and Hawaii. And for years, the Supreme Court declined to step in. Petitions were denied, appeals were left unresolved, lower court rulings, often conflicting and deeply controversial, were allowed to stand. That pattern has now broken. This time, the court didn't simply deny review or issue a narrow procedural ruling. It agreed to move forward with a case that directly asks whether semi-automatic rifles commonly owned by law-abiding citizens are protected by the Second Amendment. That question goes to the heart of the entire assault weapon ban framework. And it is the exact question the court has repeatedly avoided, until now. To understand why this case matters so much, you need to understand the scale of what is at stake. More than 100 million Americans currently live in states with some form of assault weapon ban or severe restriction. In at least 10 states, ownership of certain semi-automatic rifles is either outright prohibited or so heavily regulated that lawful possession becomes nearly impossible. These laws do not just affect future purchases. In many states, they criminalize possession itself. Law-abiding gun owners who legally purchased firearms years or even decades ago can suddenly find themselves facing felony charges if they fail to comply with constantly changing regulations. In some jurisdictions, penalties can include years in prison for mere possession. This is not a fringe issue affecting a handful of collectors or enthusiasts. AR-15-style rifles are among the most commonly owned firearms in the United States. Estimates place the number in civilian hands at over 20 million, making them one of the most popular rifle platforms in the nation. Yet in certain states, owning one can instantly turn a law-abiding citizen into a criminal. So how did we get here? The answer lies not in the text of the Second Amendment, but in a series of judicial doctrines created by lower courts over the last 15 years. After the Supreme Court's landmark decisions in District of Columbia v. Heller and McDonald v. Chicago, the court made clear that the Second Amendment protects an individual right to keep and bear arms commonly used for lawful purposes, such as self-defense. But instead of applying that standard consistently, lower courts developed their own tests. Some courts adopted what became known as the military style or military utility rationale, arguing that if a firearm resembles weapons used by the military, it can be banned, even if it is commonly owned by civilians. Others relied on interest balancing tests, weighing what judges believed to be public safety concerns against constitutional rights, despite the Supreme Court explicitly rejecting that approach in Heller. Over time, these judicially invented standards became the foundation for upholding assault weapon bans across the country. And the Supreme Court largely remained silent. That silence began to crack in 2022 with the Supreme Court decision in New York State Rifle and Pistol Association versus Bruin. In Bruin, the court made something unmistakably clear. Lower courts were no longer allowed to use balancing tests or policy preferences to decide Second Amendment cases. Instead, gun laws must be consistent with the text of the Constitution and the nation's historical tradition of firearm regulation. In theory, this ruling should have immediately called assault weapon bans into question. In practice, many lower courts resisted. Rather than striking down these bans, courts began engaging in what critics, including Supreme Court justices, later described as Bruin evasion. Judges acknowledged the new standard, then upheld the same laws anyway by stretching historical analogies beyond recognition. Laws regulating 19th century knives were cited as justification for banning modern rifles. Medieval restrictions on crossbows were invoked to defend 21st century firearm prohibitions. Some courts even argued that the more sweeping a ban is, the less constitutional scrutiny it deserves. These rulings created a direct and growing conflict between the Supreme Court and the lower judiciary, and eventually that conflict became impossible to ignore. The case now moving forward did not emerge in a vacuum. It is the result of an avalanche of litigation sparked by states aggressively expanding assault weapon bans after Bruin, not retreating from them. Maryland, Illinois, California, and others enacted or expanded laws that went far beyond previous restrictions, banning entire categories of semi-automatic rifles based on cosmetic features, detachable magazines, or vague definitions that swept in nearly all modern sporting rifles. Lower courts upheld these laws anyway. The result was a patchwork of rulings that directly contradicted Supreme Court precedent, conflicted with one another across circuits, and effectively nullified Bruin in practice. At that point, the Supreme Court faced a choice: intervene or allow its authority to erode. By moving this case forward, the court chose to intervene. The decision to hear this case sends a message that extends far beyond gun policy. It signals that the Supreme Court may be prepared to reassert its role as the final interpreter of constitutional rights, not just announce rules that lower courts are free to ignore. It also signals that assault weapon bans are no longer insulated by procedural avoidance or judicial creativity. For the first time in years, the core constitutional question is squarely before the court, and in the months ahead, the answer could reshape gun laws nationwide. To understand what happens next, you have to understand what the Supreme Court is actually being asked to decide, and why the answer could collapse the entire legal foundation supporting assault weapon bans nationwide. This case is not about policy preferences. It is not about whether judges believe certain firearms are good or bad. It is about whether courts are allowed to rewrite the Second Amendment by inventing exceptions that do not exist in the text, history, or tradition of the Constitution. And that question puts lower courts on a collision course with Supreme Court precedent. In Heller, the court ruled that firearms commonly owned by law-abiding citizens for self-defense falls squarely within Second Amendment protection. The court also made clear that this protection is not limited to firearms in existence at the founding, but extends to modern arms that serve the same lawful purposes. For years, lower courts sidestepped that standard. They acknowledged that AR-15 style rifles are widely owned, then claimed that popularity alone was not enough. Some courts argued that even common firearms could be banned if legislators deemed them too dangerous. Others claimed that rifles resembling military weapons fell outside constitutional protection altogether. The case now before the court challenges that logic directly. The petitioners argue that common use is not a secondary factor. It is the constitutional dividing line. If millions of Americans own a firearm for lawful purposes, the government cannot simply ban it by labeling it dangerous or military style. And critically, the Supreme Court appears to agree that this question must finally be answered. One of the most significant aspects of this case is the potential collapse of the military-style rationale that lower courts have relied on for years. Several circuit courts upheld assault weapon bans by claiming that AR-15s are similar to military rifles like the M16 or M4, and therefore fall outside Second Amendment protection. But this reasoning turns history on its head. At the founding, the militia was composed of ordinary citizens who were expected to bring their own weapons, often the same weapons used by military forces. There was no meaningful distinction between civilian arms and military arms. In fact, the ability of citizens to possess effective military-grade weapons was seen as essential to national defense and resistance to tyranny. The petitioners argue that if the Second Amendment protects anything at its core, it protects arms suitable for militia use. If the court accepts that argument, the entire logic supporting assault weapon bans collapses because states will be forced into an impossible choice: either admit that AR-15s are not actually military weapons, undermining their dangerousness claims, or admit they are military-suitable arms, placing them at the very center of Second Amendment protection. This case also puts Bruin itself on trial. In Bruin, the Supreme Court explicitly rejected interest-balancing tests and instructed lower courts to rely on historical tradition when evaluating gun laws. Courts were told to ask one core question: is this law consistent with the nation's historical tradition of firearm regulation? What happened instead was widespread resistance. Lower courts claimed historical analogs where none existed. They compared bans on entire classes of firearms to narrow 19th century regulations on how weapons could be carried. Some courts even argued that because modern rifles did not exist in the 1700s, legislatures were free to ban them entirely. That approach directly contradicts Heller and Bruin. The Supreme Court's decision to hear this case strongly suggests that the justices are no longer willing to tolerate what Justice Clarence Thomas later described as open defiance of constitutional doctrine. This case gives the court the opportunity to enforce Bruin in a way it has not yet done, and to send a clear message that lower courts cannot nullify constitutional rights through creative interpretation. Another major battlefield in this case involves data. States defending assault weapon bans argue that these rifles are uniquely dangerous and responsible for disproportionate harm. Petitioners counter that this claim is unsupported by crime data and contradicted by government statistics. While Bruin instructs courts not to balance policy outcomes against constitutional rights, empirical claims still matter, especially when states attempt to justify bans by asserting extraordinary danger. Petitioners point to FBI homicide data showing that rifles of all types account for a small fraction of violent crime compared to handguns, knives, and other weapons. They argue that banning one of the least used firearm categories for crime while leaving others untouched reveals the arbitrary nature of assault weapon bans. If the court accepts that these bans lack historical grounding and are unsupported by consistent data, the state's justification weakens even further. The language used by the court in granting review has not gone unnoticed. The justices specifically directed briefing on whether semi-automatic rifles commonly owned for lawful purposes fall within the scope of the Second Amendment. That phrasing mirrors Heller almost word for word. The court also asked whether lower courts properly applied Bruin's historical framework, an unusually direct challenge to the judiciary below. These signals suggest the court is not looking for a narrow ruling or procedural escape hatch. It is preparing to decide the issue on the merits. If the Supreme Court rules clearly, either that assault weapon bans are unconstitutional or that firearms in common use cannot be banned categorically, the ripple effects will be immediate and nationwide. Lower courts will lose the flexibility they have relied on to uphold bans through novel reasoning. States will face binding precedent that cannot be evaded by redefining terms or tweaking features. And perhaps most importantly, the Second Amendment will no longer be treated as a second-class right, subject to exceptions invented by judges who disagree with it. But the consequences extend beyond firearms. Because if courts can ban arms owned by millions of Americans by ignoring Supreme Court precedent, what other constitutional rights can be eroded the same way? That question looms over this case and over the legitimacy of constitutional governance itself. If the Supreme Court rules that assault weapon bans violate the Second Amendment, the impact will be immediate, sweeping, and impossible to ignore. This will not be a symbolic victory or a narrow procedural ruling. It will be a constitutional reset with consequences that reach far beyond firearms. For states that have relied on these bans for decades, the legal ground will shift overnight. And for millions of Americans, a constitutional right long denied may finally be restored. The moment the Supreme Court issues a ruling striking down assault weapon bans, those laws become unenforceable. State attorneys general cannot enforce statutes that conflict with Supreme Court precedent. Prosecutors cannot pursue charges under laws that have been declared unconstitutional. In practical terms, this means that bans in states like California, New York, New Jersey, Maryland, Illinois, Connecticut, Massachusetts, Hawaii, Delaware, and Washington would collapse at once. Pending prosecutions would be dismissed, ongoing enforcement actions would halt. Civil cases challenging these bans would be resolved almost immediately, as lower courts would be bound by the Supreme Court's decision. This is not speculation. This is how constitutional law works. When the Supreme Court speaks clearly, every court in the country must listen. A common misconception is that such a ruling would eliminate all firearm regulations. That is not what is at stake. Even if assault weapon bans fall, states will retain the authority to regulate firearms in ways consistent with the Constitution. Background checks, licensing schemes, prohibitions on possession by felons, and laws governing misuse would remain intact. What would change is the ability of states to ban entire categories of arms that are commonly owned by law-abiding citizens. Feature-based bans, cosmetic restrictions, and categorical prohibitions would face immediate constitutional jeopardy. If a firearm is in common use for lawful purposes, it cannot be outlawed simply because legislators dislike it. That principle would not be limited to rifles. Magazine capacity limits, handgun roster laws, and other categorical restrictions could fall under the same reasoning. Laws that treat the Second Amendment as a privilege rather than a right would suddenly face strict scrutiny rooted in text, history, and tradition. Beyond the legal realm, the economic impact would be significant. Manufacturers that have been locked out of major markets would regain access to millions of consumers. Firearm retailers in banned states would be able to stock products long prohibited. Supply chains disrupted by state-specific compliance rules would stabilize. Billions of dollars in economic activity could be redirected almost immediately. Gun owners who relocated across state lines or avoided doing so out of fear of criminal penalties would no longer face a legal minefield simply for exercising a constitutional right. For the firearms industry, this would represent the end of a fragmented regulatory landscape that has distorted markets for years. The political ramifications would be just as profound. State legislatures would lose one of their most powerful gun control tools. Assault weapon bans would no longer be a viable policy option. Any attempt to reenact them would face immediate constitutional challenge and near certain defeat. At the federal level, proposals for nationwide assault weapon bans would be effectively dead on arrival. Even if passed by Congress, such laws would be unenforceable under binding Supreme Court precedent. This would force lawmakers to confront a new reality. The Second Amendment is not optional, and it cannot be legislated away by simple majorities. For voters, the decision could reshape electoral dynamics. Gun rights would no longer be confined to rural or conservative constituencies. Millions of residents in traditionally blue states would experience firsthand the restoration of a right they were told they did not have. That shift could alter political coalitions for years to come. Perhaps the most important consequence of this ruling would be its message to the judiciary. For over a decade, lower courts have treated Supreme Court gun rulings as suggestions rather than commands. They have upheld laws using reasoning explicitly rejected by the court, confident that certiorari would be denied. That era may be ending. A decisive ruling in this case would reassert the Supreme Court's authority and make clear that constitutional rights are not subject to judicial nullification. Courts would be forced to apply the Second Amendment with the same seriousness given to the First, Fourth, and Fifth Amendments. No more interest balancing, no more creative exceptions, no more treating disfavored rights as optional. While firearms are the immediate subject, the implications of this case extend much further. If courts are allowed to ignore clear constitutional commands when they disagree with them, no right is truly secure. Free speech, religious liberty, due process, and property rights all depend on the same judicial restraint and fidelity to the Constitution. This case represents a test of whether the Supreme Court will enforce its own rulings or allow them to be eroded by resistance below. A strong decision here would reaffirm a foundational principle. Rights do not exist at the pleasure of judges or legislators. They exist because they are written into the Constitution. Oral arguments will draw intense scrutiny. Amicus briefs will pour in from advocacy groups, historians, legal scholars, and state governments. Media narratives will frame the case as a referendum on public safety rather than constitutional limits. But when the decision comes, likely near the end of the court's term, it will speak louder than any headline. It will determine whether assault weapon bans survive as a permanent feature of American law or whether they become a historical footnote, an example of legislation that exceeded constitutional boundaries. This case is not about the Supreme Court creating new rights. It is about whether the court will enforce the rights that already exist. For millions of Americans, the outcome will determine whether the Second Amendment is a living guarantee or a hollow promise subject to political fashion. And for the nation as a whole, it will answer a deeper question. When constitutional rights collide with political agendas, which one prevails? That answer is coming soon.